Royalty is not a tax. A 9-judge Supreme Court bench led by Chief Justice Chandrachud held earlier this week with just one dissenting view. MMTR Act 1957 did not limit states' powers to levy a tax above royalty, which miners paid, overruling an earlier Supreme Court order. In order to gain deeper insights into this topic and understand the impact on the Indian mining industry, I welcome you all to yet another insightful webinar organized by BigMint. I am Mr. Mukherjee, your host for the webinar. Along with me, I would like to introduce you all to Mr. Indranath Jha, who is co-moderating this webinar with me. Welcome, Indranath, and over to you for sharing the brief on India's mining industry.
Thanks, Nista. Quickly give you the mines and mineral position in India. India is a home to diverse minerals and has significant contribution in country's economy. India's mining sector contribution to the GDP hovers around 2 to 2.5%, and India is the second largest producer of aluminium, fourth largest producer of iron ore, and the fifth largest producer of manganese ore. India's iron ore production increases by around 10% year on year to 280 million ton in FY24 as per the BigMint data. Both the public and private sectors had a significant role to play in driving domestic iron ore higher. India's crude steel production increased around 14% in FY24 to 144 million ton compared to 126 million ton in FY23, which itself explained the surge in iron ore production year on year. Thus, any changes in regulations is likely to impact the industry as a whole. So royalty can be a major source of revenue for any mineral-rich state like Odisha, which has around 44% share of India's total mineral deposit, followed by Chhattisgarh and Rajasthan, 17% and 14%. Royalty is not a tax in the recent judgment by the Honorable Supreme Court and its impacts on industry as a whole. To understand more, I would like Mr. to take this session forward.
Thanks, Indranath. Thanks for that brief outlook and the overview that you gave related to the mining industry. Well, it's my pleasure to introduce the esteemed panelists who will be joining us in this session. Our first panelist has been instrumental in shaping the rules and regulations for India's mining sector. With over 40 years of extensive experience in esteemed organizations such as Indian Bureau of Mines, he brings a wealth of knowledge to our discussion. He has served as an assessor for quality control, NABET, a former manager geology at MECL, and a consultant specializing in exploration, mineral economics, and the auction of mineral blocks, among other areas. Please join me in welcoming Dr. Pradeep Kumar Jain. Welcome, sir. Our second panelist in today's webinar is an advocate on record and counsel at Supreme Court of India and Delhi High Court. He is also the managing partner of APT Legal, Advocates and Solicitors, a boutique law firm specializing in Supreme Court and Delhi High Court litigations, arbitration and commercial disputes, as well as environmental and mining issues. Please join me in welcoming our second panelist for today's webinar, Mr. Anand Verma. Welcome, sir.
Very happy to be here. Thank you.
Thank you so much, sir. So, beginning this panel discussion, Mr. Verma, we would like to understand from you about the recent order that has been issued by Supreme Court, its background, and what the case is all about. Over to you, sir.
Thank you, Nishta. Thank you, Indranath. The recent judgment by the Supreme Court is the culmination of a dispute which has remained pending in the Supreme Court for more than 20 years and is also one more step in the resolution of an issue which has been before the Supreme Court in different matters from the late 1980 onwards. And as those who would have had a chance to flip through the judgment, or those who may have read a summary of the judgment from various news reports would have summarized, that the judgment rendered day before yesterday is actually in a way a clarification of law which was an issue before the Supreme Court, starting with the judgment by a 7-judge bench in 1991 in India Cements. India Cements was a judgment in the context where the Tamil Nadu government had imposed a cess on land revenue, and where the land revenue was deemed to include royalty. So the cess, which was imposed by the 1958 Act, it was the Madras Panchayat Act of 1958, was in effect a cess on royalty. The litigation, after having travelled through the High Court, reached the Supreme Court, was referred to a bench of 7 judges, and the bench of 7 judges in that judgment, a majority had held that royalty is in the nature of a tax, and cess on royalty would amount to a cess on tax. That was the position which was understood in 1991, and it was thereafter entrenched in the judicial and the mining industrial landscape that royalty is a tax, that a mining lease is a statutory instrument executed between the state government and a mining lessee. It is not a mere contract. This was a position which everybody understood, which as students of law we have kind of grown up understanding the position in this manner. And India Cement was followed by various judgments of the Supreme Court. It became settled law in a sense throughout the 1990s. And I'll come to how gradually there were certain doubts expressed. But just to summarize, India Cements was followed by a 3-judge bench of the Supreme Court in Raoji Bhai versus State of Gujarat, Orissa Cement versus State of Orissa, Saurashtra Cement versus Union of India, State of MP versus Mahalakshmi Fabrics. All of these are judgments rendered in the 1990s, which followed the India Cements position and which took the line that royalty being a tax, any further taxation which had any nexus with royalty, extraction of minerals, production of minerals, or even on the mineral bearing land, to the extent that the taxation could be linked to the extraction of minerals to royalty, was not sustainable at all, could not be imposed by state government in any manner, because the field was covered. And this is important for us to understand. The position then was that the field was covered by the MMDR Act enacted by Parliament and Section 9, which imposed royalty, and only the central government could determine the rates of royalty. So this was the position in the 1990s. Doubts began to emerge in a subsequent 5-judge bench judgment of the Supreme Court. So these are all judgments by constitution benches. This issue has grabbed the attention of the Supreme Court in various acts passed by different state governments from time to time. That judgment came about in Kesoram versus State of West Bengal. And in Kesoram, the issue before the Supreme Court was not strictly qua royalty. It must be clarified, in Kesoram, it was not strictly qua royalty under MMDR Act, but it was a cess imposed by the State of West Bengal on the quantity of mineral being dispatched from a particular land, which happened to be mineral bearing land. In Kesoram, the majority judgment was written by Chief Justice Lahoti. Chief Justice Lahoti was of the view that royalty is not a tax. Interestingly, Chief Justice Lahoti was also of the view that even India Cements did not hold royalty to be a tax. But the judgment and the line in India Cement was a typographical error. It might seem interesting to all of us that such significant decisions by the Supreme Court, by 7 judges and by 5 judges, are turning on issues such as typographical error. But the 5-judge bench, through the majority of Justice Lahoti, did hold that number 1, royalty was not a tax, and number 2, even the judgment in India Cement did not indicate it to be a tax, but the line in India Cements in 1991 was a stenographer's error. That's how they called it, an inadvertent stenographer's error. So the issue, really speaking, has been simmering ever since. It was never a settled issue, and because a 7-judge bench was doubted by a 5-judge bench in a gap of 12 years between 1991 and 2003, if people were to glance at the number of the case in which the judgment has been rendered, it will be apparent that these are cases filed in the year 1999 before the Supreme Court. And the cases which were filed before the Supreme Court initially pertained to a law enacted by the then state of Bihar, later became Jharkhand, which was the Mineral Area Development Authority, wherein a tax was imposed for use of land. This is in fact mentioned in para 3 of the judgment itself. A tax was imposed on the use of land, and the measure was royalty, which included mining land. Now other states, because other states also wanted to have certain impositions on mining activities, so act issue before the Supreme Court, apart from the Bihar Act, which later on became an act for the state of Jharkhand, were acts by states of Rajasthan and Uttar Pradesh, which want to levy even today environment and health cess and fees for transporting coal and coal dust from mines. So these were the various acts which were challenged from time to time before the Supreme Court. The challenges were pending. The reference to a 9-judge bench came about in the year 2011. In 2011, a bench of the Supreme Court noticed the difference between India Cements and Kesoram and referred a multitude of issues to the 9-judge bench. Now the 9-judge bench has recrystallized the issues. Just to restate the context before the 9-judge bench, a lot of people here would recall that mines and minerals in India come within the domain of the state governments, are within the domain of states, and in our constitutional scheme, in the federal or quasi-federal scheme which our constitution has enshrined, the state governments have power to legislate over mines and minerals. The entry in issue is entry 23 of list 2. The reason that I need to go into these entries because this is the foundation of the Supreme Court judgment. The Supreme Court judgment is looking at the constitutional framework, is looking at federalism, the division of legislative and taxation power between states and the union being the central government, parliament. Now, entry 23 of list 2 is subjected to union regulation under entry 54 of list 1. And the MMDR Act is an enactment by the central government in exercise of their powers under entry 54. And participants in this seminar may recall section 2 of the MMDR Act is a declaration which those of us who are involved in mining policy and legislation use so often in section 2, that the union has declared that it is expedient to bring mines and minerals under union's control for regulation and development. Now the words here which are being used in entries 23 and 54 are of critical importance and fell for interpretation by the Supreme Court in this recent 9-judge bench judgment. Entry 23 and entry 54, entry 23 being in list 2 and entry 54 being in list 1, are therefore two sides of the same coin. So while mines and minerals remain the property of the states, the mining leases have to be executed by the states. Those of us who from the coal sector may recall this was one of the fundamental principles laid down by the Supreme Court in the Manohar Lal Sharma matter, where the coal mines were in issue and the allocation of coal mines was an issue. And the Supreme Court had held that only the state government could decide who to give the lease to pursuant to whatever rules it framed. And the central government could not give the letter of intent. So under entry 54 and entry 23 are two sides of the same coin. There are two more entries which became the subject matter of controversy or dispute and argument before the Supreme Court. Entry 50 is the legislative competence of state governments to impose taxes on mineral rights, subject to limitations which the parliament may impose by law. India Cements had held that entry 50 of list 2, which allows state governments to impose taxes on mineral rights, is also covered by the union's control under the MMDR Act. And once the union has thought it fit to impose royalty under section 9, royalty is a compulsory exaction. Whoever is operating a mining lease has to compulsorily pay royalty as per the rates determined by the central government. Therefore, it takes the nature of a tax. That was the understanding, that a mining lease is a statutory instrument, royalty being a compulsory amount that you have to pay for operating a mining lease, for extracting minerals, for dispatching minerals. It takes the nature of a tax. So therefore, the state's power to impose any taxes on mineral rights, the word used are in entry 50, taxes on mineral rights. The power is therefore denuded. It is occupied by the center and by parliament to that extent. That was the understanding in India Cements. The understanding in India Cements was also one more, that since royalty is a tax, states have one more power. So just to summarize, one was the state's ownership under 23, which is subjected to the union's regulation and development control under entry 54. Separate is the power of the states to impose taxes on mineral rights, subject to limitations by parliament under entry 50. A third power is the state's untrammeled power to impose taxes on land and buildings under entry 49. Unlike entry 23, which is subjected to the union's power, to the parliament's power to frame a law regarding regulation and development, unlike entry 50, which is again subjected to the union's power to impose limitations, and I'll expand more on that, entry 49 does not by itself state any conditions or limitations on the state's power. However, India Cements had held that since entry 50 is concerned with taxes on mineral rights, royalty it had held to be a tax on mineral right. So therefore, a sequitur or a conclusion was that there cannot be any further taxes on mineral bearing lands. It is already covered by royalty. That is how it was understood. So really speaking, the controversy or the issue before the Supreme Court stemmed from the state saying that, sorry, we do still have some power to tax. And what the court has held in India Cements and all of those cases throughout the 1990s may not be correct, because our power to tax cannot be taken away completely. And which is why a huge feature of the judgment, both the majority judgment by 8 honorable judges and the dissenting opinion by Justice Nagarnath, a huge feature of both the opinions, the majority opinion and the minority opinion, is fiscal federalism. How much do the unions have power to tax, and does it eclipse, does it completely take over the state's power to tax? Now, in analyzing this, the first significant conclusion which the Supreme Court gives, the majority opinion, and we are concerned only with the majority opinion now, because as in our constitutional scheme, once the Supreme Court gives a judgment, the majority view is the judgment. The dissenting view is a dissent. It carries weight in terms of as a counterpoint, as something which is in disagreement with the majority view. But the judgment of the Supreme Court is the majority view and nothing else. So I think that there needs to be a lot of clarity about this. The Supreme Court majority view firstly holds that a mining lease is a contractual understanding between the state and the lessee. So the earlier entrenched understanding that a mining lease is a statutory instrument and therefore a royalty is a compulsory statutory exaction. The word I'm using, exaction, is the word that all the lawyers, all of us used in the arguments before the Supreme Court. The Supreme Court says, sorry, that's not the case. Because a royalty is an amount that you are paying to the lessor, whoever owns the minerals. The owner of the mineral in most cases is the state government, but in certain cases can also be a private party. So that's the consideration you are paying to the owner of the mineral for the privilege of extracting and dispatching the mineral. It is not in the nature of a compulsory exaction. It is distinct from tax, and the judgment at length deals with this issue. The judgment at length deals with what is a tax. A tax is imposed by a sovereign, whereas a royalty is being imposed by the lessor, mostly the state government, in lieu of the privilege granted to a lessee for extracting minerals. So the two there, the court says, the majority opinion says, cannot be compared. So another argument that we raised before the Supreme Court was, while appearing for the industry, it was that the term used in entry 50, limitation imposed by Parliament, includes the MMDR Act in totality, includes the imposition of royalty under Section 9. So firstly, the Supreme Court holds that royalty is not a statutory exaction, it's a consideration. Secondly, it also holds that royalty is not a tax, and the state's taxing power under entry 50 cannot be so easily eclipsed without there being a specific limitation imposed by the Union, by Parliament, by law. This is of grave significance. The court has held that Section 9 is not a tax. It does not in any way eclipse the state's power to impose taxes on mineral rights. Of greater significance is the takeaway by the majority opinion that the Parliament still has the legislative competence to impose limitations on taxes on mineral rights. But the word used is limitation. They have interpreted the word limitation very widely under entry 50. They have said Parliament can, by amending MMDR or whatever suitable law, can even prohibit states from imposing taxes on mineral rights. But Parliament by itself does not have any power, according to the judgment, to impose taxes on mineral rights. So the second big takeaway is that taxes on mineral rights can be imposed by states. However, subject to any further law that Parliament may frame to impose limitations on such taxing power. The court says that the present MMDR as enacted, as existing today, is not a limitation. There will need to be something further. The court has also taken into account, there were some queries that I was receiving, that states are charging premium because of auctions. The royalty share is going to the states, DMF and other exactions are going to the state. The court has taken note of all of these amounts being charged from the lessees at present. It is noted in the judgment. But the court says just because these amounts are currently being given to the states does not in any way mean that their constitutional taxing power is abridged or taken away. A third takeaway is regarding taxes on land and buildings, which, as I said earlier, is not subjected to any limitations by Parliament. Unlike taxes on mineral rights, which are subjected to limitations by Parliament, taxes on land and buildings are not, the entry is not subjected to any limitations by Parliament. That's an untrammeled right of states. That the court has held that it is within the competence of state legislatures to impose taxes on land and buildings, and as long as the nexus is with land, the quantum of tax can even be based on mineral produced or royalty. So a tax on mineral bearing land which has a nexus for the purpose of charging of tax, rate of tax on the royalty or the mineral being produced, the court has held to be valid. But all of these acts which were in force, which were in issue before the Supreme Court, will now be placed before division benches or appropriate benches for testing whether the nexus is satisfied or not. The last point that I want to just cover in the overview is that the further hearing which is scheduled on the coming Wednesday on 31st is not at all in any manner a hearing which will have an impact on the judgment already rendered, except to the extent that whether the judgment will apply prospectively or retrospectively. So the only issue which is now sub judice, and which therefore it will not be appropriate to deliberate what the court will hold, because it's really up to the court, it's a sub judice matter, is whether they want to clarify that these principles, constitutional principles, federal principles that they have laid down today, will they apply to all the acts which were already in force, or will they apply prospectively?
Thank you so much, Mr. Verma, for your beautifully explained the whole acts and the constitution regarding this. Just I have a follow-up questions like, is this include the coal and the other atomic mineral as well,
It includes everything.
and auction, non-auction both?
Everything. The only exclusion are oil fields and petroleum products, which the court has specifically said are not included, even though provisions are similar. But everything which is otherwise covered under the MMDR Act is included under this judgment.
Okay, thank you. Just bringing the Dr. Jain into the discussion. Now we would like to know that what are the current taxes being levied on minerals like royalty, DMF, and NMET, and their importance to the industry, sir.
Okay, sir. Thank you very much. And our co-panelists, learned co-panelists, who try to make a thing simple and set the platform. And you are asking that how this, what are the presently how this industry is having a tax. So as rightly pointed out in this majority judgment, the royalty is not a tax. So we take away this royalty is not a tax, but still this royalty has to be paid by the under Section 9 of the MMDR Act 1957. That the mine lessee has to pay the royalty in respect of the mineral they have removed or consumed, whatever it may be. So, and the royalty has to be paid to the either to the state government or to the owner of the land. Specified rate, and the rate has been notified in the Schedule 3 of the MMDR Act, which now and then has to be revised, subject to the having the mandate has given in the Section 9. So presently the rate of the royalty has been in force in the 2014, and after that there is no revision has been taken place. And other than the royalty, after the 2015 amendment, there is a district mineral foundation has been in the Section 9B of the MMDR Act, and 9C there is a National Mineral Exploration Trust. So, and before that there was already either royalty or dead rent under the Section 9A was there. So we can say that the burden on the mine owner is royalty or dead rent, then the NMET and DMF. So their rate is also there. 2% is there for the NMET of the royalty, or 30% for the pre-auction mine, and 10% of the auction mine is a rate for the DMF. So this is a part of it. When we are taking inclusively, for a common man, it is whether it is a tax or whether it is not a tax. How much is going he is paying from his pocket, while making the mineral commodity saleable or mineral commodity for the valuable product. So other than this, under the Section 9, A, B, C or 9, there is a auction premium that rightly my learned panelists say. The premium also has been taken as a part of a judgment that the mine owner, after the 2015, premium also has to be paid. So this is also to be paid coming from the pocket of the mine owner. Then other than that, there is a GST is also there on the minerals. Then there is a already, though there is a judgment was making on the subject of the cess, but few states like Rajasthan, like Uttar Pradesh, there was already a cess base there on the mineral products and the mineral commodity. Just like if I give a name, there is an environmental and the health cess. Then there was a cess for transportation of the coal or coal dust from the mine to the area. Then other than that, if the mine is having a trading in the other than the international border, then there is a export and import duties is also there. And a part of it being a citizen of the country and governed by the income tax law. So income tax also has to be paid by the individual mine owner. So in conclusive, we can say that that's whatever the judgment is there, majority or minority, their burden is going to come on the mine owner, and ultimately that is going to be transferred for the consumer. So a part of it, anything more, if you specifically are thinking, then I will elaborate.
One more question I have. I mean, already the stakeholders are already concerned about the royalty on royalty issues, and could this move of tax royalty or putting extra tax on the miners, will this not be aggravate the situation?
Actually, this royalty on royalty is a very pioneer and since long the issue was put forth by the industries, but this issue has not covered in it. And other than that issue has already been taken care by the Ministry of Mines. It was an agenda for the National Mineral Index also. So most probably whatever the present practice is going on, it will continue. There will not be anything disintegration of the royalty. Royalty will be intact, and it will be by this judgment also it has to be notified or revised by the under Section 9 by the central government, and it has to be collected by the respective state governments.
Okay. My next question to Mr. Verma, that you said that the royalty is not a tax, but before that the royalty was collected by the state government, is given directly to the central government purse, I guess. Now it will be advantage to the state, right? Is that the case?
Very much. See, the royalty collection mechanism may not change because it is still under the MMDR Act. The mechanism and in the way it is right now structured, that will not change. What it allows the states to do is to have more flexibility in their taxing powers, to have, as is obvious, taxes that they can impose. Mr. Jain rightly mentioned the Environment and Health Cess, which was the act in issue before the Supreme Court as well. So the royalty structure will not change. That will remain what it is.
Okay. So ultimately the state will be benefited, right?
Very much so.
Landmark decision.
Very much so. The decision is please sir, please go ahead.
I would like to add it earlier also, whatever the royalty or taxes they were, except this handmade, everything was in the domain of the state only, whether it was imposed by the center or it was imposed by the state. So there is some addition cess is going to be made by the state, or a tax imposed by the state under the different entry of the list 2. Then also that is going to be state the domain only. If it is coming, some part is coming into the center like income tax or a duty of the export and import, but they are also going back as a grant of aid to the state only.
Okay. So again, Mr. Verma, as you know that India is charging the higher royalty across the country, and this mineral-rich countries, if we put this higher taxes, won't be it's a greater disadvantage for the miners. I mean, we are not discouraging the miners to mine. I mean,
see, those are issues of policies. Those are issues of how states want to attract more people to do business within their territories, and how they want to balance the attractiveness with their revenue generation, right? So these are obviously conversations to be had between the industry and states, that whether such multiplicity of levies will encourage people to invest or will discourage people to invest or increase production, sustain production, etc. Right? What I can say is that when a constitutional court and a Supreme Court is dealing with constitutional issues, mostly they take into account ground realities, but the ground realities don't necessarily, and the impact it may have, do not change the way they interpret the Constitution. And while the dissenting judgment does note this, that there are limited states which have huge mineral reserves. Justice Nagarnath's opinion notes this, and it also notes that if a particular state were to levy very high rates of taxes, it would distort the end users across the country. It would distort supply for end users across the country. And therefore, the reasoning in the dissenting opinion is that federalism has to be skewed in favor of the center, and there has to be uniformity. This is the argument made and rejected by the majority. So if in a way you look at it, it's how the majority and the dissenting opinion have two different takes on what fiscal federalism means in the context of mineral bearing lands and the power to tax.
Okay. Mr. Jain, recently we have seen the Indian mine blocks auctions have resulted in significant premiums. So if any additional tax imposed, it will be further burden miners, especially the merchant ones.
Sir, actually, the whole, if you make a detailed analysis of this judgment, we just can have a revision. What is the existing, the revenue has to be paid by that. So the cost of the production will going to increase in addition to the cess or a tax imposed by the state government because of this judgment. So definitely this is a cascading effect will be there on value addition. And whoever has taken the mine on premium, they will set their goal based on the available tax structure. So if there will be any additional tax on them, definitely their whole exercise of their going to be recalculated, and sometimes will not be able to be that much successful after making the block in the auction.
Mr. Verma, my next question is to you. With states gaining more power, won't it disrupt the level playing field across the nation?
Possible, but as I replied to the earlier query by Indranath, I think, and this is, it's impossible to speculate because it depends on how each state wants to move forward. But I think there'll have to be a rationalization between their attractiveness for doing business, which is a key word today, and while at the same time augmenting the resources. So every state will have to bear in mind that industry will not be keen to have multiple levies on it, and that will, and see what we also need to bear in mind is that the important caveat left by the Supreme Court that Parliament can still make law and limit the taxing power of states, and that's a very important takeaway from the judgment, which I'm sure the industry has noted more than all of us, and they would be taking it up with the central government. So that what the Supreme Court says, that taxing power for mineral rights can be limited, may be enforced by law by Parliament through appropriate amendments in the MMDR Act.
Right. Dr. Jain, my next question to you, that we did discuss that there could be a probable hike in the production cost and could impact the overall steel prices. Any other expected impact do you see from the order in the near term?
Yeah, madam, rightly you said that because this cost of the production plus whatever the cess or the royalty or the other taxes has been paid, the total become a sale value. So when the sale value is going to increase, definitely the value added product, which is depending upon service for iron or steel, for the bauxite there is a aluminum or alumina, definitely the value added cost of are going to be increased. This will be a cascading effect on the value added product. And other than that, there is because our tax structure is going to be a little bit compared to the other countries or compared to the countries where they are giving a attraction for the investment, definitely we are going to have a challenge for the attraction on the FDI also. And that has been rightly our co-panelists told. It is a minority single learned judges covered all these points. There will be poor FDI, so there will be a challenge on the federal structure. There will be sometime one state will have some different type of the tax, other state will have a different type of the tax. So this all going to be make a little bit, you can say, the situation where the common pan India basis things whatever existing in present going to be have a big challenge.
Thanks, Dr. Jain. Yeah, Inna, do you want to add something?
Yeah, we have the certain question from our participants that, especially for Mr. Verma, I think the most probable question is the royalty 18% on royalty 18% tax will be continued after this discussion.
Indranath, the issue of GST and service tax on royalty is pending before a 3-judge bench of the Supreme Court. It was listed. I opened the order because I saw the question in the chat box. It was listed just last week on 24th of July, right? And it's been, earlier this week before this pronouncement, and those matters have been listed for hearing in the 3rd week of August. So I don't know. We'll have to study and bring out some new arguments before the Supreme Court on in August for the issue of GST and service tax. Because earlier it was service tax decided by the Rajasthan High Court. Matter traveled to the Supreme Court. Various other petitions from across the country have been tagged or clubbed together with that litigation. Later on, the system changed to the regime changed from service tax to GST. So that issue is currently pending. This judgment is a 9-judge judgment. It will be binding. It will have a huge bearing, a huge impact on, whatever decisions are taken in the GST and service tax issue. But yes, that issue is still pending before the Supreme Court.
Okay. Another interesting question is coming. Another interesting question coming. I think auction premium is a tax. Whether you consider it a tax or a royalty.
Auction premium is an amount being charged pursuant to tender conditions. It is neither royalty nor tax. It is, in fact, the auction premium is noted specifically in para 249, where the industry has argued that states have multiple revenue streams already from the mining and mineral sector. They mentioned royalty dead rent. They mentioned DMF under 9B. They also mention auction premium received from successful bidders under the mineral auction rules. The court notes all of this and says this doesn't limit their taxing power.
Okay. So these are the questions questions we have from the participants. For further, I would like Mr. to take this session forward.
Well, I think most of the questions we have been able to address, although if we can see some more questions, we will surely take those questions and try to get them answered from our esteemed panelists for this webinar. Well, thanks Dr. Jain and Mr. Verma for joining us. As we draw close to the webinar, there are some key takeaways that we could make out from this webinar. That mining lease is a contractual agreement, and then states taxing power cannot be eclipsed under Section 9. So royalty is again not a tax now. The next Supreme Court hearing, which is scheduled next week, is probably to decide whether the new charges or the changes that have been coming up will be charged retrospectively or not. It covers majority of all the products, including coal and atomic minerals, is what we understand under this new Supreme Court order that has come up, and applies to all minerals, and also applies to both auction as well as non-auction mines. Then, of course, as very, very quick and early to assess the impact of the order, but yes, as per the discussions with the industry experts and our panelists, we do understand that there could be an increase in the production cost and overall mining cost from the miners' end, which will again be passed on to the steel industry as a whole. So that were a few key takeaways, and definitely we'll keep a check on the developments that take place on this. Once again, thank you very much, Dr. Verma, Dr. Jain and Mr. Verma for taking out time from your busy schedules and joining us in today's webinar. It was truly insightful to hear your perspectives.
Thank you very much.
Thank you, Nishta. Thank you, Indranath. Pleasure to interact with all of you. Thank you.
We are excited to announce that BigMint will be also hosting its 7th Anode and Pellet Summit, along with the 4th Indian Coal Outlook Conference and the 6th Indian DRI Scrap and Steel Conference. These events will be taking place on 22nd to 23rd of August 2024 in Gurugram. Do join us for deeper insights from our esteemed speakers over there. Thanks everyone for joining in. I'm your host, signing off from the webinar. Thank you everyone.
Thank you.